Well, good morning, everyone, and welcome to the last morning blend of 2025. I'm Alison DiFlorio and honored once again to have my partner in crime here, Lori Armstrong from CM Law, joining me for today's conversation. Hello, Lori.
Hello, how are you this morning?
A little chilly, but other than that, doing fine. Hoping all of you had a wonderful Thanksgiving holiday and are geared up for hearing kind of a whirlwind of things this morning to get you thinking about what you need to plan for 2026. For those of you that have joined us before, you know that this is a program that Lori and I have been running for what, about 5 years now, Lori?
I
Something
I
like that.
I think it'll COVID was this is crazy, everybody. Ready? In March, it will be 6 years since the world shut down for COVID. And I think we started these before
Oh,
COVID.
you're absolutely right. So it has to be six
It's been a
years. I'm kind
while.
of, and yeah, time is in a warp ever since the
Yeah.
pandemic.
Yep.
But we attempt to bring to you what's happening, what the legal updates are for business leaders, for HR professionals, and then what we're seeing in trends from the human resources side, so that you can think about how that may impact your workplaces. I will share with you that some of the things that we share today may not apply to all organizations, but we wanted to make sure that we are giving you a broad stroke of legal updates and in HR trends for both for-profit and nonprofit sectors. A couple of housekeeping tips before we get started. This is being recorded, so we will be sharing a copy of the recording with you after the session. And a big thank you to Whitney Beasley, our marketing director, who's behind the scenes making sure that you all get the invitations and that everything works and that you get the follow-up materials. Your phones are on mute, your computers are on mute, but your questions are important. So we will be monitoring the chat. Feel free to uh, ask any questions that you have. If we don't have time to address them today, both Lori and my contact information is at the end of the presentation, and you can feel free to reach out to either one of us after that. I think that's all of my housekeeping tips. We will do some quick introductions. I know some of you have met Lori and myself before, but for those of you who have not, I am the co-founder, managing partner of Exude Human Capital. We are a full service HR consulting firm headquartered in Philadelphia, but we service the entire country. And our focus is really on helping organizations, whether it be on an ongoing basis or by project, on a whole host of HR related matters, everything from HR assessments to outsourcing, interim, or ongoing support, performance management, HRAS optimization and implementations. And we also have a strong learning and development practice so that the HR processes, practices, and policies that you've put in place can be effectively executed by your leaders. We always talk about the importance of management training, leadership development. So just know that if you have questions about those things, we're happy to help. And with that, I want to turn it over to Lori to share a little bit about her and her firm.
Hi, everybody. For those of you who haven't met me, I have been practicing exclusively in the area of workplace law for almost 30 years. I don't know when that happened. My oldest daughter was born while I was in law school, and she's getting married in May, and it still freaks me out because I feel like it was just yesterday. But I really am passionate about this area of law. I've long represented only employers of many different sizes and different industries, profit, nonprofit, and I also so I do employment litigation, discrimination, wage and hour, that sort of thing, as well as traditional labor. For those of you who know me, I talk a bit about my experience in that realm. And my favorite things to do really are training and proactive counseling and things to really help. This sounds so cheesy, but I really believe this: help employers be the best employers they can be. And so towards that, I also serve as a mediator with the EEOC, and I corrupt young legal minds as an adjunct professor at Temple Law School. So that's a little bit about me. On top of my older daughter, I have a younger daughter, and I have two huskies, and so all of those things take up all my free time. But
And Lori, thanks again for being such a great partner with Exude over the
yeah,
years.
no, I'm so appreciative of our friendship and our partnership. So thanks for having me.
So, onward to today's brew. We've got some top developments that Lori's going to walk you through from the legal perspective. We're going to talk about the OBBBA and its impact on employers, some updates on some of the federal agencies, and then we'll talk about some HR trends that we're following for 2026 around AI, total rewards, and workplace flexibility. So, without further ado, Lori, I'm turning it over to you.
All right. Um, I was trying to recap everything we had done over the past year in our various discussions and was looking to see, what things we had talked about. Some of this is that, and some of this is my own sort of research about what was really heavily reported. So these are, top developments. I may have missed some, but they give you kind of a snapshot of what happened in the past year. Of course, we saw a rollback of DEI programs for federal contractors. There were several executive orders, one of which cut the Department of Labor's OFCCP by 90%. So if anybody here does federal contracting, that would have affected you. There are practice groups in many law firms that specialized in affirmative action plans and OFCCP audits and things like that. And all of that has come to somewhat of a screeching halt. And I think we saw more generally, um, not just specific to federal contractors. We saw changes in DEI at other federal agencies that impact private employers as well. So even though the statutory language of Title VII hasn't changed, that is, it has been always unlawful to discriminate under Title VII on the basis of race, color, national origin, sex, and religion. The focus of the EEOC has shifted as the administrations have changed. And so, whereas I think you would have seen EEOC guidance focusing on underrepresented groups in the workplace and making sure there was no discrimination against those folks. We've seen, we'll call it a pendulum swing now, where the EEOC guidance emphasizes that any DEI programs, they're not unlawful, but if you have one, they cannot result in, and this is the language from their guidance, unequal access to mentoring, training, nor workplace networks, reinforcing strict non-discriminatory practice across all jurisdictions. All of that language is accurate and has always been the case. But I think there has been a concern by this administration that um, I guess what we previously would have called the majority population, white men in particular, maybe to a lesser degree, white women, that there has been this notion of, and I'm using air quotes, but reverse discrimination. And I use air quotes because the Supreme Court does not acknowledge reverse discrimination. Discrimination is discrimination, and it can never be based on, employment decisions should never be based on those protected classes, nor age, nor disability. Um, Regardless of who's in office, quite frankly.
And if
Um,
I could just add, from the HR employer perspective, we're still seeing work in this space continue under the umbrella of human resources. I mean, and really under the focus of inclusion and belonging. So we have seen some of our employers drop certain language from websites or from career websites. However, the work in creating equitable and inclusive workplaces continues.
yes, yes. And I referenced the Supreme Court because, if you may recall, I discussed this case earlier in the year, but the court considered the question of whether or not the standard required to prove a case of discrimination under Title VII should be different depending on the plaintiff's race in that case. Um, in other words, would it be a higher burden for somebody who was white to prove discrimination than for someone who was black? And the Supreme Court said, no, the standard is the standard. You can't treat people differently based on race. And I mentioned that because sort of interesting, because with respect to, in particular, gender identity and transgender protections, there's a conflict between the executive orders under this administration, some of the EEOC guidance, and the Supreme Court's decision regarding whether gender identity is protected. I am going to talk about this a little bit longer. Some of the others will kind of just run through. But this, to me, is a kind of a showdown to see eventually how our separation of powers is going to shake out. The Supreme Court, as you may recall, issued a decision in 20, I don't remember now if it's 2019 or 2020. Justice Gorsuch, who was a Trump appointee, authored the decision. And in that decision, the Supreme Court held that under Title VII, the word sex includes gender identity and sexual orientation, so that those classes are also protected from discrimination under federal law. The executive orders and the EEOC guidance kind of walk back protections for gender identity. And I'm just going to give you a personal example. I was actually asked by the EEOC to be on a panel to do a presentation on preventing harassment in the workplace. And we had to submit our slides in advance. My portion of the panel was simply to review developments in the law. And you can't talk about Title VII without talking about the Supreme Court decision Bostock. And the commission scrubbed any reference to Bostock in the slide deck. So there's this very real tension between the judiciary and the executive branch right now as to what those protections should be. You should pay attention to your state and local laws as well. Oftentimes, for example, in New Jersey, in Philadelphia, in Pennsylvania, generally analyzes its state statute in accordance with federal law. All of those are enforcing the law to include sexual orientation and gender identity. But again, this is actually sort of a broader, could be a broader issue to see how we're going to shake out who has the final word on these things. So, less exciting, and let me be 100% clear on this. I am not a tax lawyer. I do not play one on TV. I cannot give tax advice. There's all the fast talking at the end of the car commercial. But I will reference what I can read publicly available. Don't ask me for tax advice. But under the OBBBA, as it's called, which was signed on July 4th, there is a reduction on taxes on overtime and for tip income. And under that laws, workers can deduct up to $12,500 of overtime from their taxable income. This provision sunsets in 2 years. So it's not a permanent tax reduction. And I believe, although I'm not sure, that it phases out depending on your level of income. For example, the tip credit income or tip tax reduction. A lot of people are like, no taxes on tips. That's not really how it works. Up to $25,000 on pure gratuities, not imposed taxes. So not when the restaurant adds the tax on for the server, can be deducted if the employee makes less than, I think the threshold is 150,000, and that impact is really based on what your tax bracket is. So if you're in like the 12% tax bracket, I think it translates to several $1,000s in actual value. So it gets really confusing. And I think part of Alice and I, what we'd like to do is to make sure that you have accurate information and that you can do with that what you will.
I think the big thing for HR professionals who on the call who do have tipped employees is you are going to have to uh, talk with your payroll providers to make sure that you can report on overtime weekly. So in order to accurately report for end of year tax filing purposes. And Lori, correct me if I'm wrong, but this is effective retroactively to Jan 1, 2025. So this is going to be your first year of reporting on this. I know I've talked to a couple of the payroll providers that we speak with, and I know Paylocity's, they're all working on it. But make sure you tap that resource because they can help you get things structured to be prepared to report on this.
Yeah, it's really, again, not a tax lawyer, but it's really much more complicated than the media tends to portray it. They're like, no taxes on overtime, no taxes on tips, and that's actually not entirely accurate. And so other people who went to school for accounting and tax law are available to help you, and you really should consult with them as well as your payroll provider. Okay, two other kind of top developments in 2025. This isn't anything new. Allison and I have talked about these before, but background checks, ban the box, privacy laws are continue to evolve, not on the federal level, but on the state and local level. Philadelphia has a ban the box law. Um, there had been at the federal level several years ago a initiative by the EEOC to look at disparate impact, the impact of arrest records and criminal background checks, and whether they disproportionately impact people of color. I'm going to talk about disparate impact again in a few minutes. Suffice it to say, that's no longer on the agenda for the federal agencies, but it does continue to evolve on the state and local level. And Allison's going to spend a bit of time on AI in general, but obviously I can't go anywhere right now without talking about AI or automated decision systems. And California, this will be no surprise, I think, to most people, is leading the way on legislation in this area. They have proposed the No Robo Bosses Act, which would require human oversight of AI tools used for hiring, firing, and promotion. I think that it's still in the proposal stage. I don't think it's been voted on yet. But it's not unusual for California to do something and then New Jersey or Massachusetts to follow shortly thereafter, Philadelphia to be in that mix as well.
And New
Pennsylvania
York.
is a state. I'm sorry, I meant to mention New York. Pennsylvania as a state tends to be a little slower to evolve, but um, this is, I think you're going to see a lot of this in 2026.
And this is interesting because this was this the in the big beautiful bill, they originally said that states were not able to regulate differently from the federal government, but that was stricken from the final version of the bill. So to Lori's point, as we and I'll talk about this, just be prepared to keep up with what your state is doing.
Yeah. So let's talk about that bill. It's now an act, and some of the provisions that impact employers. I already referenced a couple of these. The tax exclusions for tips and overtime. Again, it's really a deduction of, it's no real different than a charitable deduction. If you sort of think about it, if you do your own taxes, it is it's not taken off the top. You can not count this amount of income to reduce so that you can pay less in taxes overall. That's kind of the goal of it. We talked about the tips and overtime already. The child care tax credit, um, unlike the deductions, is a credit, and they work a little bit differently. I only know that from doing my taxes, not from being a tax lawyer. Um, but in this case, the employer provided child care tax credit um, will cover up to $500,000 for larger employers and even more for smaller employers. And it covers 40 to 50% of eligible child care expenses and is intended to be indexed for inflation. Now, if you aren't a tax paying entity, I don't know that it has an impact on you, but again, you should check with an accountant or a tax advisor.
And this is a big change from what it had been. So it had been $150,000 in prior to this. Uh, so just, when we talk about later about total rewards for thinking about uh, this tax credit for those employers that are eligible for it, and adding additional childcare resources. Think about that because this could be a way for you to offset that cost.
Yeah, I mean, the tax code, tax policy is one of the ways the government can try to influence behavior. So the purpose behind the tax credit, the paid family medical leave that I'm going to mention in a minute, student loan repayment, is to encourage employers to provide those benefits to the employees. And philosophically, that aligns with um, folks who believe that private entities should be doing those things rather than have it through a government program or something like that. So, the paid family medical leave, I want to be clear, it's not that the government is going to give you paid family medical leave. There are states that do. New Jersey has a paid family leave act. Pennsylvania does not. The city of Philadelphia does have a paid sick leave ordinance that might apply to certain situations. New York has paid leave laws. But this particular provision within the OBBBA is intended to permanently extend the tax credit for paid family and medical leave so that employers can claim a tax credit of up to 25% of qualifying wages, again, designed to incentivize employers to provide paid leave benefits rather than having the government require that employers provide paid leave benefits. So, like the FMLA requires that covered employers provide 12 weeks of unpaid job protected leave under certain circumstances. Um, this doesn't change that requirement, but it provides a tax incentive for an employer then to, on its own, pay people who are eligible for FMLA leave. And then lastly, student loan repayment, same thing. Um, if employers want to, it's sort of like tuition reimbursement on steroids. If they want to repay employee student loans up to 5250 per year, they can do that without it being counted as taxable income. And I'm sure this folds into this total rewards
Mhm.
concept that Allison, you're going to talk about in a little bit.
Okay.
So now I'm just going to talk briefly about the big three federal agencies and what's going on there. Now, these are the EEOC enforcement statistics for FY 2024. We don't have the statistics for fiscal year 2025 yet. Um, so I'm not sure, honestly, how relevant these are because we're waiting to see how the change in administration impacts the type of charges that have been filed. But I can tell you that in fiscal year 2024, 88,512 new charges were filed, and that is a continuation of an uptick that we've seen over the last several years. Interestingly, I did not put this on here. Pennsylvania is one of the highest states for EEOC charges at just over 5%. Um, California is up there. I think Texas. It's if you want to, you can go to the EEOC.gov website and there's a statistics portion and it tells you percentage wise how many charges are filed in each state by what type of claim, whether it be age, disability, race, gender, national origin, religion. And so it's kind of interesting to see those sorts of trends. 56% of all the charges that came in last fiscal year included a retaliation claim, making it the top issue. Not surprising. Those of you who've heard me talk before have heard me say don't turn a meritless discrimination claim into a meritorious retaliation claim. So I'm sure you all know, but quick reminder, retaliation claims are based on when an employee either uh, raises a complaint of discrimination or participates in an investigation into a complaint of discrimination. And as a result of that protected activity, the company cannot take discriminatory, retaliatory, harassing conduct towards that employee because they have engaged in that protected activity. Doesn't mean you can't manage them, doesn't mean they can't get written up for legitimate policy violations or what have you. But the closer in time the protected activity to the adverse employment action, the more it looks suspicious, sus, as the kids would say, by the way. All right. Disability discrimination uh, charges were 35,000. It's a more frequent allegation. I'll be curious to see if those go up, given some other changes in the law. Well, it's not really in the law, in enforcement strategies or initiatives. There was an increase in pregnancy discrimination charges after the Pregnancy Workers Fairness Act took effect. Um, just so you know, in terms of money, the EEOC secured $672 million. That would include settlements and litigation. And the median jury award in federal employment trials was $350,000. Although over 95% of those cases settle um, before they ever get to a jury.
But that doesn't include your cost to defend, right?
Nor does it include attorney's fees.
So when you're thinking about, I just want to make a couple comments here. Those last two numbers, and you're justifying the actions you're taking as HR professionals to do proactive training or investments in HR to make sure that you are mitigating risk. Use those numbers.
Well, yeah, I mean, to your point, Allison, the 350 is just the award to the employee. On top of that, a prevailing plaintiff has their attorney's fees paid by the employer, the defendant. So you can add on another couple 100,000, and then you have your own cost of defense. So that 350 is misleading. The total cost of a employment case is probably closer to a million, based on this average that the EEOC put out.
The other comment I just wanted to make was about that disability discrimination charges as kind of rising to the top. As we think about return to the office, you can anticipate that there might continue to be an uptick in ADA claims or disability discrimination charges. So we can talk a little bit more about that when we talk about workplace flexibility.
So I'm going to just kind of run through the information on the next two slides on the EEOC because I've talked about this before. The one thing that you may recall is both the EEOC and the NLRB, the National Labor Relations Board, were short board members or commissioners, as they're called at the EEOC, and did not have a quorum and couldn't really take the initiative to do some of the things that the agencies normally do. Well, in October, Brittany Paniccio was confirmed joining the chair, Lucas and Kalpana Katagal. And as a result of this, they now have a quorum and they can do some stuff. So when I say do some stuff, you're going to see the pendulum swinging opposite direction from what we've been talking about for the past 4 years. So you can expect to see changes in the enforcement guidance that was issued in 2020 or three, I can't remember now, on harassment in the workplace, particularly the portions that relate to protections for transgender employees. And you could see changes on regulations on the implementation of the Pregnant Workers Fairness Act, particularly portions related to the coverage of reproductive health under the definition of pregnancy, childbirth, and related conditions. Some of those provisions were under challenge and litigation. And so you could just expect there to be changes with respect to those things. The EEOC closed all pending disparate impact cases. The Title VII has long been read to prohibit intentional discrimination, but also policies and practices that, while on their face neutral, disparately impact people on the basis of one of the protected classes. So the EEOC for quite a while has been, when they do an investigation, also requesting information, looking for quote pattern or practice, or which is related but not exactly the same thing as disparate impact. Most of the significant EEOC investigations, such as DEI, alleged discrimination, related to that, gender ideology, religious rights, LGBTQ, are also being, they're kind of in the early stages, and we're not quite sure how all of that is going to shake out, given the, as you'll see on the next slide, the commissioner's stated initiative. You can see here that she stated that the priorities of, quote, rooting out unlawful DEI motivated race and sex discrimination, protecting American workers from anti American national origin discrimination, and defending the biological and binary reality of sex and related rights, including women's rights to single sex spaces, protecting workers from religious bias and harassment, and remedying the other areas that have been historically under enforced by the agency. So this is a swing from what we've been seeing, and you can expect there to be an increase in charges and investigation and perhaps litigation in those areas. Lastly, but consistent with the stated initiative, in the early summer, the EEOC released the 200 days of EEOC action to protect religious freedom at work. And it outlined actions the EEOC had taken during or has taken during the Trump administration to defend the religious liberty of American workers. Those actions include COVID-19 vaccine mandates, challenging those mandates, religious based accommodations, and anti Semitism on college campuses. So while I would say it's been a little sleepy at the federal stage, I think now that the EEOC has a quorum, you're going to see some activity and some increased enforcement, but not in areas where we had seen enforcement in the past.
So be prepared.
Yes. Department of Labor, very briefly, that again is kind of an agency that's we're not really hearing a lot. We kept seeing that we would expect things to happen. One relating to the white collar exemptions and whether or not that salary threshold should be increased or not. The first level of increase went into effect a year ago. And then, as you may recall, in November of last year, a federal court in Texas vacated the rule, finding that the rule placed too much emphasis on the salary level and kind of skipped the duties-based test for exemption, and found that the automatic indexing for future updates bypassed certain administrative procedures, and therefore that the agency had overstepped. So we thought maybe something would be put in its place. It hasn't. So this is the stay tuned. The other thing that happened was back in May, the DOL issued a field assistance bulletin and advised that it wasn't going to enforce the Biden era rule that defined the term independent contractor, but instead was going to rely on criteria set forth in a DOL 2008 fact sheet. So that's quite a
That's
while
going back
ago.
a bit.
I got to tell you, and I'm not supposed to say this as a lawyer, but I do think sometimes some of these are semantics or differences without a real distinction. At the end of the day, it goes to the level of control that an employer has over an individual in setting the terms and conditions of employment. The closer that relationship is, the more you tell them the when, the where, the how, and pay them directly, the more likely they're going to be your employee. The more attenuated those, connections are, the more likely they'll be an independent contractor.
So end of year, always a good time to kind of review your contractors. If you do have independent contractors, review how you're handling them today, to Lori's point, to make sure they're uh, categorized accordingly.
Yes.
Appropriate.
The National Labor Relations Board, lastly and briefly, I'm sorry, there's this fire truck going by, so I apologize for any background noise. Um, I think I've mentioned many times they're supposed to have 5 people on their board. They currently have 1. Um, you may recall that President Trump fired Commissioner Wilcox. She challenged. I don't think that the actual underlying litigation has gone all the way through, but the injunction piece, the court let her termination remain in effect while the challenge to the substantive questions are being litigated. So um, he also fired the general counsel like within a few days or weeks of taking office. Biden had done the same thing to the previous general counsel. So we're seeing huge swings of the pendulum at the board level. All of that said, 2 board members and a general counsel have been through the hearing phase, and we're just waiting on the vote. So that if they succeed at the vote, we will have a general counsel and we will have 3 members of the board, and that's enough for a quorum. It's still too short of what they're supposed to have. In the absence of activity by the federal board, we're seeing a lot of stuff on the state level. And the acting general counsel issued a release sort of admonishing those folks and reminding them that at the end of the day, federal labor law falls under federal policy and um, really supersedes pretty much any state action within this particular space. Um, So we'll have to wait and see, you know, once the vote takes place, what they do. But I think on the last slide here, what you can expect would be rollbacks on pretty much five big cases that came down during the Biden administration. You may recall, because this would apply to everybody, the confidentiality and non-disparagement provisions that were deemed to be uh, coercive and infringing on the Section 7 rights of employees by, telling them they can't talk about certain things and, uh, that would somehow interfere with their ability to organize or otherwise engage in protected concerted activity. I would imagine that this board will look to roll that back. Work rules and policies, we've seen back and forth. You all might remember during the Obama administration, feverishly rewriting all your handbooks to comply with rules that might be, and those rules, by the way, or these cases apply to all employers, not just employers that have unions. And then we saw during the Trump administration a swing back where your rules are not being scrutinized at the same level. They got scrutinized again under Biden. So we might be rewriting handbooks again in the next couple of years. Um, Big thing regarding union recognition. I don't really want to spend a lot of time on this because we have other things to talk about, but basically the Biden board was seeking to, I guess, frankly, make it easier for unions to be recognized as uh, employees' exclusive bargaining representative under certain circumstances where it appeared as though the employer might have violated the National Labor Relations Act, even um, for less egregious violations. That's the Cemex case. The Biden board also expanded remedies available to workers. In the past, most cases were remedied by some sort of back pay uh, payment to an employee who was, for example, wrongly terminated, maybe a notice posting. Um, Prior general counsel Jennifer Abruzzo believed that the remedies should include any foreseeable consequence. So if somebody lost their job and then they lost their car, that the employer should be responsible for those uh, damages beyond just the wage loss as well. And lastly, this came out really towards the end of the Biden administration. During union campaigns, there's something called mandatory or captive audience meetings where the employer has the opportunity to give its point of view, why it believes that a union might not be the right thing for the workforce, and employees, have to come and sit in an employer meeting. And the previous general counsel believed that those were inherently coercive and violated the Section 7 rights by really not allowing the employee to choose not to participate in those meetings. And so captive audience meetings were held to be unlawful under the NLRA. That would be another case that I would think that the current board is going to look to overturn during this administration. Now, I will say that for any of these that the board might be looking to overturn, they have to have a case that comes up that fits within that issue. So if there are no cases in the pipeline, they can't just sort of overturn the case with a new case law. I suppose they could engage in rulemaking, which is another way of, you know, implementing laws or policies and procedures under the agencies. Um, but that the National Labor Relations Board has never had much success in rulemaking, except with respect to the handling of union elections. So that is kind of everything, and still not everything that's going on at the federal level. It's a really weird time to be practicing labor and employment law, I have to say. So
I
let's
think it's
talk. Go ahead.
equally interesting and strange to be in the HR space now as those of you on the call may agree because it's difficult to predict where things are going with any degree of certainty because there's just so much change happening. I do think before we get into the three trends that we wanted to talk about today, I wanted to do some context setting for where the workforce is today. And this is based on some recent survey data. I think the last time we met, Lori, we talked about that quiet cracking where
Yeah.
people are feeling they're on the edge of, losing it and but not necessarily it's not showing up blatantly, but it may show up in less discretionary effort to do more than they are being asked to do. But if you take a look at some of these stats, there are high levels of employees reporting unmanageable workloads, and that's both at the management and non-management level, high reporting of burnout rates. And interestingly, it's a little bit lower for those who work remote or hybrid, but it's still pretty significant, a significant increase in burnout compared to where it had been, even 2 years ago. We see reports of remote workers feeling exhausted. So for those of you who work remote and you're on back-to-back calls from the minute you wake up to the minute you end, you probably know where that may be coming from. I think this 37% of employees feeling respected at work is declining. Like only 37% of employees report feeling respected as work. And what we know, I mean, that's close to 40%. When people stop feeling respected, that's when you do have to worry about engagement levels, about potential claims, about potential unionization. I mean, those are fairly high numbers. And now more than ever, it's important for managers to be schooled and educated and build confidence and competence in soft skills of how to communicate with people. When I think about these workforce trends with kind of the national discourse or national kind of negative tone that you can't, people are feeling, right? There's no kind of divide between work and life anymore. It's all blended together. So we have to take this into consideration because what happens to employees comes into the workplace now. So that's just for context. So what are we seeing as far as trends that we want to talk about today? And Lori had mentioned this earlier, AI and HR. So I feel like it was just yesterday we were saying, oh, it'll be a while before it's really in our workplace. Well, this is happening faster than I think anybody ever anticipated. The adoption pace, they're seeing now that 43% of organizations use AI and in some HR tasks, certainly up from 2024. Anyone who's using an HRIS system knows this because it really showed up first and foremost in the recruiting lens. And in publicly traded firms, it's even higher. I think what we're seeing now is it's interesting to see how HR is using AI. When I think about the stats that we just shared, with increasing workloads and people feeling overwhelmed. This is a time for HR to really dig in and help organizations determine which tools are out there that can provide some efficiencies or take some of this feeling of workload off employees, not just in human resources, but perhaps throughout an organization. It certainly isn't without risk. And there are a couple things I want to mention here. If you do have an HRAS system today and you are using it for recruitment and selection and perhaps performance management and data analytics, make sure you talk with your provider to get as much information as you can as to how they go about training the system, how they can, if they do audits of the system around potential bias, because that's the one big risk factor that we're seeing here. I'll give you an example. We demoed a tool just recently that was really slick. I mean, for an HR professional, particularly in the recruitment and selection piece, boy, it would really save you a lot of time and be able to match open recs with potential candidates across a huge spectrum. But interestingly, when we dug in and started looking, it matched based on job titles, not on skills. So if you think about that, you might have people that worked in a job that had the skills you're looking for, but the job title didn't match what the tool was pulling for. So you're potentially not including a large group of people who could be qualified candidates for your job simply because of the way the system is programmed. So dig into your systems and really start educating yourself and your teams on how you can provide some human oversight to the tools that are giving you efficiencies to make sure that those you're not taking the risk of potential bias. I also heard another clever way that it's being used in performance management to analyze performance reviews to identify trends that can then help inform where you focus your training dollars or how you can communicate to executives where you see the opportunities to develop the workforce. So AI can be incredibly helpful. You should really establish some sort of uh, bias audits or adverse impact testing. I'm not saying you have to do that, but check with the systems that you're using to see if they provide that. And we'll see where this all goes in terms of the state regulations that Lori and I were talking about earlier, if that becomes now something that is mandated for vendors that they have to disclose information or validation of results or mitigation methods, or be able to contract for audit rates that annually they're doing some sort of an audit. The other thing that we recommend is that you establish, and we've said this before, internally an AI kind of council, and it can be across different departments within the organization. And they can look at different tools, help to vet different tools to see how they might be able to support employees in skill development or efficiencies. And then you can come up with a list of fully vetted preferred tools that employers can use, as well as a set of policies as to how you can use them. I know, Lori, I think we've shared before, in the absence of that, people might get into AI and use it and rely on what it delivers without double checking the information. There's that case in New York City, I believe, where an attorney delivered a brief, but it was all cited. He hadn't double checked, didn't do the human review of what AI generated, and I think the guy was disbarred for failure to do so.
Cases weren't even real. So,
Yeah, yeah,
yeah.
and
Look, I
I
mean,
think we talked about that. AI can hallucinate,
mhm.
so you have to make sure that you have that human oversight. But it is a great tool and can certainly create efficiencies and help with some of the workload issues that perhaps we have.
Yeah, I just to echo that, two things. I think people are concerned about privacy and accuracy. And some of us old heads, as my kids would say, may sort of shy away from the technology because we're afraid of those things. But I was listening to an AI speaker and they were like, that would be like saying, I'm not going to use email because we don't know, how it works. So we do need to be careful. I think you're going to see pushes for protections because of those privacy and accuracy concerns. But also, I think pretending that AI is not a thing is dangerous.
Yeah, and I think I just read that Citigroup is mandating training for all of their employees on how to effectively use prompts
Hmm.
to tailor the information that you're going to get. So I just think there are many creative ways out there that people are starting to educate the workforce, and then put in some of the guardrails on how you can effectively use these tools and which tools to use.
Yeah, and I know this is particularly an issue in law firms, but I expect it's going to be or is already for HR as well. And that is how you protect confidential information. Which AI service are you using, and what do they do with the information that you provide? So that's
Mhm.
part of that privacy concern, I think.
Yeah, there are a couple comments here asking how are you using HR, and someone's using it to summarize and outline certain documents before presentation. There's some great training tools to develop training, for those of you that are asked, hey, we need to do some staff training on XYZ. It's a great way for you to very quickly develop a base that can save you hours and then tailor it to meet the needs of your organization. It's also great for job descriptions, at least to get a base job description, and then you can tailor it, or for documents or policies and things like that. Again, always with the human insight or oversight. Let's see here. Okay, so healthcare and total rewards. Well, I don't think you can turn on your radio in the morning or listen to anything without hearing about the cost, the rising cost of benefits. And if anyone has been through your open enrollment yet, I'm sure you're not shocked to hear that the average increase is well over 20%, and it's rising. So employers are facing, premiums that they've not seen in years. All of this gives us an opportunity to step back and rethink total rewards and how can we take this moment in time to reimagine what it can look like and build in factors. Make sure that dollars that you have that you're allocating for an investment in total rewards is allocated appropriately for the demographics in your organization. We think about not just the healthcare costs, but also personalized flexibility within your choices of benefits. So not just the healthcare, but also the other lifestyle benefits that you may have, so that those who are joining your organization fresh out of college and steep with student loans, and Lori referred to this with the 5250 annual uh, deduction that you or the payment you can make to offset costs of student loans, whether that's through a 401k match, a lump sum, or monthly payments. That may help that group. For that middle group that might be starting families, uh, are there child care benefits that you might be able to offer or maximize that child tax credit, and partner with local agencies that are closer to where you work so that when you do ask people to come back to work and they do have children, that they have some lower cost options or convenient options for childcare. And then, toward the end, the retirement benefits and different flexible arrangements to perhaps work on a more part-time schedule as they're starting to sunset. All of these different things you can think about now more than ever to craft a flexible package that appeals to a wide range of demographics within your organizations. We recommend always that you survey employees to find out what matters to them. So rather than try to think, oh, this is what Lori wants and this is what Allison wants, just ask them and see what the trends are, and work closely, with your leadership team and your brokers to figure out where can we save or potentially offer different healthcare plans to reduce costs, to allocate those dollars towards other things that might be impactful. Um, think about tiered designs. Think about modular benefit plans. So again, that's student loan aid, fertility services, elder care. That's a big one too. The mental health, not all healthcare plans cover mental health well. So you can think about supplementary programs that might be able to give dollars to support mental health therapy, et cetera. And always financial coaching. And then integrate that flexibility. And we're going to talk about that because when you think about benefits, working hybrid, working remotely is a huge benefit for some people. It's not for everybody, but think about different creative ways that you can embed flexibility into the workplace. Which leads us to trend number 3. Oops, did I go backwards? The workplace flexibility. So depending on what report you read, it varies. But 88% of employers are providing some sort of hybrid option. That can be as little, that can be a day a week, that can be flexibility in your start times, in core hours. But we are seeing that in Q3 of 2025, job postings reflect 24% of job postings reflected a hybrid work environment and 12% fully remote. So those numbers have been holding pretty strong in the last couple of years. We do see that there is a high demand, there continues to be a high demand for employees looking for some sort of hybrid arrangement. I think what's interesting here is the stats show that companies save money when people work remotely. Employees equate returning to work as adding six to $12,000 uh, to their costs. And if you break that down, what they're talking about is commuting costs. They're talking about cost for lunch and coffee, believe it or not. They're talking about cost for wardrobe, all of the things that they've now experienced that they didn't have to pay. So when you think about creating your total rewards package, there is a real financial element to providing workplace flexibility. Not to mention the fact that just from the reported data, people who do work remote and hybrid do feel as though they are, even though I said earlier that they're stressed or they feel that their workload is high, they do report that the flexibility of being able to do things while they're in their home and not losing time on the commuting time has been hugely beneficial to them. So think about flexibility by age group. Again, think about it as what does early career need? What do mid-level career need? What do late stage career people need or want? And again, use your survey tools to find out what's important to people. Um, Quantify remote work's value. If you are offering workplace flexibility, do some due diligence to be able to quantify what the value of that is. And don't be afraid to share that as part of your total rewards to make sure that you highlight it. I always say with our employers, having a really robust benefits plan is only part of the equation. Being able to effectively communicate it so that people understand it and take advantage of it is really the big win. And it's not just once a year at open enrollment, it's throughout the life cycle of an employee experience. And then make sure that if you do have remote and hybrid work, that you do have a connection infrastructure built, something where you have regular check-ins with managers, regular meetings. If you are bringing people back full-time, make sure not everybody's not sitting at their desk on Zoom calls next to the person that they're in the Zoom call with, but rather create those experiences that it's intentionally designed to have a social experience while you're in the office. You've got to have those touch points built in, regardless of the workplace structure you land on. So just to kind of recap here, think about establishing an AI oversight group. Think about it from a compliance perspective, from input, from insights, from a total organizational standpoint as to how can you make the most out of the tools and resources that are out there. Revisit total rewards. Do that survey, identify areas of concern, and take action to address. There is not a one size fits all here. So you really have to be creative, might require a little bit more effort and work. Be clear on whatever workplace model you do have. I think one of the things that we see more than anything, and Lori, I don't know if you see it, but the when organizations say, okay, this is what we're doing, and then only half of the group actually does it. We are all coming back to work 3 days a week, except that these 10 departments don't come back 3 days a week, but those do. So there has to be consistency across what you decide to do with your workplace
Yep,
model.
that'd be
Um,
great.
we talk about continuing to build enthusiasm with the whatever workplace model you have and with your people. Give them autonomy where you can. Give them in decision making, scheduling it where you can be flexible. We know that that builds engagement and enthusiasm. And as always, educate and support your managers.
Train your managers.
Train them, please train them. Train them on the laws, train them on how to communicate with empathy, train them on what your updated policies and processes are, and train them how to lead in any kind of work for whether you're hybrid, remote, or on site. Okay, Lori, any last words or
It's
any
a
questions from our group?
Yeah, well, I'll give you some last words while we're looking to see if there's any questions. I know a couple of people have to run. It's a rough time of year. It is a great time to kind of do a review of your policies, your procedures, audit your practices, and schedule some training early in the year for your managers because they still remain the front line and your greatest asset and your greatest risk, quite honestly. So, but as always, I just want to say it's such a pleasure to spend this time with you all and with you, of course, Allison, and I'm looking forward to 2026.
Yes, and we wish everyone a very happy, safe, and peaceful holiday season, and we look forward to seeing you in 2026. Have a great one.